Hey, I'm firearms attorney Gilbert Ambler, and we are back today to talk about the way that a panel of the 11th Circuit Court of Appeals judges did their best to overrule Bruen, or at least to try to find their way around Bruen. We're going to talk about the tactics that they're using, but before we dive into it, if you have not yet hit that subscribe button, go ahead, hit subscribe, like this, comment, share. That way you and your friends can keep getting this pro Second Amendment related content. All right, the decision that we're talking about today comes from the 11th Circuit Court of Appeals. It's a case known as NRA v. Bondi. And the case involves the ability of those between the ages of 18 and 21, so 18, 19, 20-year-olds, to purchase certain firearms under Florida law. Now, we all know that there is, across the entire country, a prohibition on FFLs selling handguns between the ages of 18 and 21. However, Florida passed a law in response to Parkland that restricted selling assault weapons to persons in those age groups. And this finally made its way up to the 11th Circuit Court of Appeals, and they briefed back and forth on how Bruen affected this case. And of course, we would have thought, looking at Bruen, we would have thought that clearly there would be no founding era laws that could support a tradition of similar restrictions that could just apply Florida's laws. But boy, would we have been wrong in coming to that conclusion, because sitting on the bench was Rosin Rosenbaum, an Obama appointee. And if you're curious whether you can tell that she's an Obama appointee, you only need to make it through the first couple of pages to see terms like fully automatic assault weapons capable of shooting 60 rounds per minute to know that she's an Obama appointee. And as we read this opinion, what we see is a couple of things. The first is something that we talked about in our prior video on how different lawyers are trying to avoid the Second Amendment's clear mandate. And what they're trying to do is they're trying to redefine the people. Now, the 11th Circuit did not decide that 18, 19, and 20-year-olds were not part of the people, predominantly because Florida did not argue that. However, the judges noted as though they think that Florida should have argued that. So possibly, had Florida argued that, the judges might have decided that a 19-year-old was not part of the people, something that we clearly disagree with and that I think the early militia statutes disagree with. The second thing that they do is they shift the time frame, okay? They bump the time frame from the relevant era being 1791 to Reconstruction in 1868. And they do that by saying the Second Amendment was applied to the states via the 14th Amendment in 1868, and so that is the relevant time period to assess when assessing the history and tradition associated with the Second Amendment. Now, this is hugely important because in 1791, there were no or virtually no restrictions on 18, 19, 20-year-olds possessing certain types of firearms. And this made sense because it was a lot of 18, 19, 20-year-olds, and even younger than that fought the Revolutionary War, okay? But when we fast forward to 1868, and we start imagining the aftermath of the Civil War, all of a sudden between 1868, where you had 3 states or territories, according to Florida, that had similar restrictions on 18, 19, and 20-year-olds possessing certain types of firearms. By 1900, there were an additional 16 states, according to Florida. So if that were the relevant time period, then yeah, there probably is a tradition that they can use to support these restrictions. But of course, it's not the relevant time period. Not only if we go back to Bruen, does Bruen make it very, very clear that later history, Reconstruction era history, can be used to support something that you think was true in 1791, but it cannot be used to overrule the understanding in 1791. But common sense also tells us this. And common sense tells us this because for none of the other rights out there do we have 2 separate classifications where one applies to the federal government and a separate classification can be applied to the states. Because that's really what the 14th Amendment did, was it took the Bill of Rights and applied it to the states. But we don't view them differently simply because the right was later applied to the states. No, we still apply the original understanding as it was understood at the time of the founding, which is what Bruen did. And apparently Bruen should have been more clear on this point because judges are going to try to dodge the Second Amendment by using this logic. In fact, it calls to mind a quote from Bruen itself, where in Bruen, Justice Thomas said, "A constitutional guarantee subject to future judges' assessment of its usefulness is no guarantee at all." And I think that's exactly what we're seeing here. Obviously, I think this was a terrible decision. I think it was a wrongful decision. I think it has to be appealed up, and hopefully a higher court will correct this. In the meantime, if you enjoyed this content, go ahead, hit subscribe, like this, tell your friends. Until next time.